Good morning and welcome to our latest webinar in our online platform series where we're having discussions around the intellectual property theme, but with a focus on issues that can arise when promoting your brand online, and in particular with influencers. Throughout this series, we've talked about different IP issues, including conversation with your speakers today, Rory Leachman, and also with Andrew McWhirter, looking at patent litigation in Scotland. My colleagues here, Rafiq, Carly Duckett and Matt Phillip, also presented a seminar in this series in which they discussed working with influencers and how best to manage relationships to help avoid disputes when promoting products. Just small couple of housekeeping points to go through. To keep background noise to the minimum, you're all on mute. There is an opportunity to ask questions. You just use the Q&A function or the chat to post any questions that you might have. My name's John Mackenzie and I'm a partner in the commercial disputes team. I'm joined by Rory Leachman, a solicitor in the commercial disputes team. Today we're going to be talking about legal grounds to challenge activities that go on when you're dealing with the promotion of brands and using these influencers. Although there's some criminal offences that can be committed as a result of online behaviour, we're not going to cover them today, nor are we going to cover publishing information online that's a breach of confidence or infringes on the right to privacy. The courts in Scotland have recently had to grapple with the issue of whether there's an expectation of privacy in private WhatsApp messages. If you're interested in that, Rory has written an article about it that can be found on our website. So the topic of discussion today is working with influencers. And influencers have been around forever. There's always been someone who has been speaking about product, promoting it subtly or unsubtly, and other people have looked to for guidance around whether they should buy this product or not. The interesting thing these days is that there are so many more platforms available for people to talk about products. Just looking into it, there's Instagram, Facebook, YouTube, Twitch, Discord, TikTok, Reddit. These are all streaming platforms, and there's a huge long list of other more specialist platforms. But the point really is that it's an opportunity for people just to get in front of a laptop, start to talk about their areas of interest, and have others engage with them in a way that's almost completely uncontrolled. And this leads to all sorts of interesting and difficult legal problems. One of the first is defamation. And that's when we have people saying things about other individuals and other businesses which are not true, and people get very upset about. So I'm going to pass over to Rory, who's going to talk a bit about defamation.
Morning all, thanks John. Yeah, so defamation concerns statements or allegations that are made online that are false and can therefore be potentially damaging to a business or an individual's reputation. In Scots law, we say that such statements are defamatory. In England and Wales, although they also fall under the law of defamation, defamation's subdivided into slanderous and libelous comments. So slander concerns a spoken statement, and libel concerns a statement that's published or broadcast. But for convenience today, we're just going to use the term defamation. Until relatively recently, the law of defamation in Scotland and the law of defamation in England and Wales differed. And this was because in England and Wales, the law was overhauled in 2013, and much of the law in Scotland continued to rely upon the common law. However, in August this year, the Defamation and Malicious Publication Scotland Act came into force. What the 2021 Act aims to do is to modernise and simplify the law of defamation in Scotland to create a better balance between freedom of speech and protecting a person's reputation, and make the law easier to understand and use. For today's purposes, we're going to focus on the changes introduced by the 2021 Act, and where any differences remain between the law of Scotland and that of England and Wales, we'll make that clear. So the first legal issue that the courts will consider is what amounts to defamation. For a statement to be defamatory, the meaning of the words used must lower the claimant in the estimation of right-thinking members of society. In a more modern parlance, the test is really whether the words would tend to make ordinary people think worse of you. The 2021 Act brings the law in Scotland into line with that in England by introducing a serious harm test. This acts as a threshold test. Harm to the reputation of a body that trades for profit is not serious harm unless it has caused or is likely to cause the body serious financial loss. So examples of defamatory statements include criticisms of a person's actions or character, unsupportable statements regarding an organisation's ethos or service. So the establishment of a fake social media profile in someone else's name might be defamatory, subject to the content. In Scotland, it was previously possible to bring an action for defamation, even if the defamatory statement had been made only to the claimant. That's no longer the case, and the statement must now be made to a third party, which is the same as in England and Wales. Another change that the 2021 Act introduced was the time limit for bringing an action for defamation. In England and Wales and in Scotland, the time limit is now 1 year from when the publication of the relevant statement first came to the attention of the person bringing the action. It was previously 3 years in Scotland, so it's quite a significant change. Of relevance for today's discussion is that the limitation period is interrupted for what the 2021 Act calls media complaints and expert determination. The parties must agree in writing to try to resolve the dispute by way of a complaints process by referring the matter to an independent person that handles complaints relating to the publication of material in the medium in question to make a determination on the merits. Significant changes have also been made to the law in Scotland about liability that will have consequences for online behaviour. And I'll pass over to John to discuss some of that in more detail.
Yeah, in Scots law, before the coming into force of the 2021 Act, each publication of a defamatory statement entitled the claimant to bring a separate claim, even if the same or substantially the same material had been published previously. This was known as the multiple publication rule, and it meant that each time a publication was read by a new reader or otherwise republished, the 3-year time period started again. Under the old law, if someone other than the original author of the defamatory statement published this statement, then a claim could be brought against them as well as the original author. This was because the law presumed that the secondary publication was intentional. In the online context, that meant that each hit on a website by a new reader in Scotland, each retweet or each like on Facebook amounted to republication, with the clock starting to run from then. Similarly, the secondary publisher was equally liable with the original author, subject to the exceptions that online platforms allow or enjoy. The multiple publication rule ceased to apply in England and Wales from 2013, and so in England and Wales, defamatory statements are subject to a single publication rule, which, as the name suggests, means that the clock runs from the date of the first publication and doesn't restart with each successive publication. With the coming into force of the 2021 Act, a secondary publisher is not liable, provided that their involvement with the statement does not materially increase the harm caused by the publication of the statement. While this will mean that the majority of people who retweet a defamatory statement will not be secondary publishers, it raises an interesting question for people with larger online followings. So we can see an argument being made by made that an influencer or a celebrity with a large online following who retweets a defamatory statement could be said to have materially increased the harm done, whereas the ordinary person, the average person with a small number of followers would not. And perhaps one of the highest profile defamation cases that we've seen in recent years is the so-called Wagatha Christie case with Colleen Rooney and Rebecca Vardy. In the context of online platforms and defamation, it's of interest because the statement was published by Mrs. Rooney on Twitter, Facebook, and Instagram. We're not going to go into the facts of the case because they've been well trailed, but in this case, the maker of the statement was clear. But sometimes identifying the maker of or the author of a tweet or post isn't always so straightforward, particularly where online platforms are involved, because it's relatively easy for users to remain anonymous. We'll discuss later some options for dealing with anonymous users when we're discussing practical steps you can take instead of going to court. In the Wagatha Christie case, the courts had already determined the meaning of the words as part of a preliminary hearing. And in the substantive trial, in which Rebecca Vardy, Colleen Rooney, and others gave evidence, there was no dispute that the words were defamatory. However, Colleen Rooney successfully established the defence of truth. In other words, the judge said the sting of the statement was substantially true. So I'm going to pass to Rory now.
Thanks, John. The Wagatha Christie case obviously concerned the defamation of an individual, and some of you will no doubt be wondering what a business or an organisation can do if it's been defamed online. And while a claim for defamation is a personal action, what that means is that only the person who believes they've been defamed may bring proceedings. But the person can be a natural or a legal person, such as a limited company, a partnership, or a charity. One thing to bear in mind is that a defamation claim cannot be assigned or brought on someone else's behalf. And what this means is that a business cannot raise a court case alleging defamation against an individual on behalf of the business's CEO, for example. However, if both the CEO and the business have been defamed, the business can sue in its own name. This is because while businesses may not have suffered injury to their feelings, they have a reputation to protect. In England and Wales, the courts have previously said that a business can only be defamed by statements accusing them of actions they are capable of performing. So, for example, accusing a corporation of adultery would not be defamatory. Nowadays, however, the effect of the serious harm requirement that we discussed earlier is that the organisation must demonstrate that it has suffered serious financial loss. And we consider that this is likely to restrict the ability of an organisation to sue for defamation in England and Wales and in Scotland.
So moving on, and thinking back to the free flow world of the online streaming platforms, where people are engaged in discussions about their activities, their hobbies, and their interests. And as part of that, they come across products. And in a non-commercial context, you can see that people say, I like this product, I like that product. Where it becomes problematic is where the influencers start to endorse products on a paid basis or make reference to products to support either their platform or as part of a sustained advertising campaign. So it's in that context that we often come across instances of misuse of trademark rights. Now, we've discussed copyright in the previous webinar, so I'm not going to go there just now, but trademarks are another intellectual property right that can be infringed with this kind of activity. So looking at trademarks, most platforms' terms of use include a provision which prohibits users from posting content which infringes another user's IP rights. Instagram's terms and conditions, for example, say you can't post someone else's private or confidential information without permission or do anything that violates someone else's rights, including intellectual property rights, for example, copyright infringement, trademark infringement, counterfeit or pirated goods. Twitter's terms of service is much the same, explaining that Twitter has the right to remove any content that violates the user agreement, including, for example, copyright or trademark violations or other intellectual property. That being said, honest use of a trademark in a descriptive manner or use that cannot be said to be in the course of trade is acceptable and will not infringe a trademark owner's rights. In the online context, examples of this are, as I've mentioned, when somebody is saying, I use this product, or I enjoy making use of that product in blogs, social media posts, and so on. What's happening is that the author or the poster is making it clear what brand they are using. However, unauthorized use of a trademark in the course of trade will be infringement. The trademark is an indicator of trade origin. An example of an online trademark infringement, for example, is a website that's deliberately incorporated as trademark in order to confuse a consumer into thinking they've landed on the trademark owner's website. Another would be a Twitter or Instagram account that incorporates a registered trademark in order to give the impression of affiliation with a brand in order to sell the goods or services. And finally, an online advertisement, and that includes a discussion about a product that compares services with those provided by reference to a registered trademark, but doesn't fairly compare them, is not a lawful comparative advertisement. And we'll discuss fraudulent online advertising in more detail later. Comparative advertising is a whole area in itself. So back to Rory.
So as John's explained, it's clear that registration grants the owner the ability to protect their trademark. However, not all businesses or organisations will have registered their mark or that they use for their brand, but that does not mean that there are not ways to prevent others from using it. One other remedy that you can use in the case of unregistered marks is the law of passing off. And the principle underlying this is that one party is not entitled to sell their goods or services under the pretense that the goods or services of another party. So there are three things that you have to establish in order to establish passing off. You have to show three things. First is goodwill. So you have to show that there is goodwill or reputation attaching to the goods or services, which has been concisely described by a judge as the attractive force which brings in custom. You have to show that there's a misrepresentation by the other party to the public, which, intentional or not, that leads the public to believe the goods or services offered by them are your goods and services. And you have to show there's been damage to your reputation because of that misrepresentation. In the context of online platforms, this will be of particular concern to brands and businesses because the UK IPO has identified that influencers are becoming an important and effective vessel for the sale and marketing of counterfeit goods. More specifically, in November last year, the UK IPO published the findings of its research into the impact of complicit social media influencers on the consumption of counterfeit goods, finding that 10% of those who participated in the research project were encouraged to purchase counterfeit goods by social media endorsements. So if consumers are misled into thinking that a website or a stream or a YouTube page is endorsed by that of the brand owner, or is that of the brand owner because of the third party using their name, then the brand owner might be entitled to bring an action in passing off if they suffer damage as a result. And in effect, what passing off does is prevent third parties benefiting from another party's endeavours in order to profit from the goodwill built up by your brand. The UK government is also taking action to regulate fraudulent online advertising and other scams. And in March of this year, the government presented its online safety bill to Parliament. John will now outline the rationale behind it and discuss and give an overview of some of its provisions.
So the online safety bill is hugely controversial. It's an attempt by the government to intervene where, because there's a perception that platforms are largely unregulated and something must be done. It's in the context of this discussion, we're not able to cover all of the provisions of the bill, but it's of significant interest to brand owners and those with intellectual property rights. So it's not law yet, but it's expected to come into law sometime in 2023. If it becomes law, it's expected to be brought into force gradually, with the full effect of the Act not felt until the end of 2024. While the bill proposes duties of care and obligations on the providers of certain types of online platforms, the relevance for many today is that it's likely that the platform's terms of use and policies will be amended to reflect the bill. In particular, in the context of today's seminar, the bill imposes a duty on providers of certain regulated user-to-user and search services to take steps to address paid-for fraudulent advertising. These providers have not yet been defined. The bill refers to Category 1 and Category 2 providers. However, it's anticipated Category 1 will be the bigger or popular sites with higher numbers of users. And the bill currently provides that Category 1 services will need to put into place proportionate systems and processes, brackets, whatever that means, to prevent or misuse or minimize, in the case of search engines, the publication or hosting of fraudulent advertising on their service and remove it when they're made aware of it. It will mean companies will have to clamp down on advertisements with unlicensed financial promotions, fraudsters impersonating legitimate businesses, advertisements for fake businesses, and so on. The government has specifically stated that its intention is that this should capture boosted social media posts, which influencers pay to have promoted more widely. Should the bill become law, these provisions will significantly assist in engaging with online platform providers where you come across fraudulent or misleading posts that are infringing intellectual property rights. We're going to continue to monitor the bill and provide updates as we go, because it's a very significant piece of legislation. What we've done is covered some of the main legal grounds for challenge. What we're now going to look at is some of the practical steps that you can take and things that should be taken into account when you decide whether or not to take action. Now, no disputes are the same, and in some situations, the identity of the infringer will be known, and the impact on your business will be so significant that it really does justify taking immediate legal action. However, some of the factors we think should be taken into account when you're looking at taking legal action is the amount of time it takes. So you need to engage the management team, and there are inevitably costs. What about cash flow? Is the management time, legal costs, and other costs incurred, how do they compare to what you think you're losing? What's actually possible in terms of the outcome? Is the court order actually going to be effective? How long is it going to take? Or has the moment passed, for example? And is it worthwhile bringing what can often be quite long, drawn out proceedings? So in most situations, it's almost always worthwhile just taking a moment to think. We're wired for action, so we always think that we need to move quickly, do something, but sometimes you just need to step back. With a defamatory comment, for example, that's a great example of the person who's referred to being outraged, and they want to take action now. But are your customers aware of the statement? Is it actually having an effect? So what is the actual damage being caused? How many people are actually going to engage with the statement? And by engaging with the statement, responding to it, you actually increase the prominence of the post, and you can see often there are unintended consequences when an originally defamatory post gets more traction because of the engagement with it. And if you raise a court action, newspapers and other social media users are perfectly entitled to report that, as long as they're reporting the court proceedings. And so you'll often see a repetition of the defamatory statement in the press. So raising a court action may attract more interest to the allegations and add fuel to the fire. Court actions can also be drawn out, as I've said, and it just builds and builds and builds. By contrast, sometimes if you just leave it and ignore it, it dies away and is never spoken of again. I'll pass to Rory now.
Thanks, John. The practical points that John has discussed will obviously be factors in any court action, but there are other practical steps that an organisation or business can take instead of going to court. So most online platforms will have procedures in place to address infringements of intellectual property rights. John discussed earlier, for example, Instagram and Twitter's terms of and conditions and their user agreements. What you can do with content that infringes your rights is report this to the online platforms directly. So Instagram, for example, has a defamation reporting form, which is accessible via its help centre. And this is particularly useful if you simply want to see the content taken down, and especially in the case of where you don't know the identity of the maker of the statement. Usually, prospects of success are not guaranteed in those circumstances, and some of the platforms will take a harder view on freedom of speech, and it will depend on what the content of the post is. If, in the example of a registered trademark, they tend to be more cooperative once you've proven that you have the right to the registered mark. But ultimately, the decision to take down does rest with the platform provider. Where most of these large online providers operate from jurisdictions in the US, they're governed by US law, and there are what are called safe harbors built into US law that effectively mean that even if an online platform has been put on notice of infringing content, they won't be liable for content that's posted, provided they exercise little or no editorial control over that content. And with Twitter in particular, as I mentioned, they take a rather harder line and have previously stated that anonymous and pseudonymous speech is important to it and is central to its commitment to defend and protect the voices of its users. Twitter frequently also receives non-governmental information requests to disclose account information of anonymous Twitter users, in effect to unmask the identity of the user, and it frequently objects to such requests. So between July and December 2020, for example, Twitter only complied with 48% of these requests by non-governmental users. So you can see that while the takedown procedure can be useful for certain intellectual property rights, it's not always the case that it's guaranteed success. But one main advantage is the fact that this is effectively a free process for you to try and get the objectionable content removed before going to court. Another option that you can employ is to complain to the Advertising Standards Agency. And earlier in the seminar, we discussed options around fraudulent advertising. The Advertising Standards Agency is the UK's independent regulator of advertising across all media, and it applies two principal codes in relation to advertising products in the UK: the non-broadcast code and the broadcast code. Where a company has editorial control over any influencer content, any post created by the influencer promoting the company's product or service must comply with the codes, as well as complying with relevant consumer protection legislation. The ASA has taken steps to advise marketers that they should hold evidence to support all claims that are likely to be interpreted as objective. And in the absence of sufficient evidence, the ASA is likely to consider objective claims to be misleading. Codes also provide, amongst other things, that the information contained in any marketing materials must be honest and truthful. Therefore, ensuring the accuracy of all information contained in marketing materials being promoted in the UK is vital if a statement is to be deemed objective. Now, the ASA can take action if an advert is misleading, harmful, or offensive, and either a business or an individual can submit a complaint. And therefore, marketing communications must not mislead consumers about who manufactures the product, discredit or denigrate another product, marketeer, trademark, or trade name, take unfair advantage of the reputation of a competitor's trademark, a trade name or other distinguishing mark or indicator of origin of a competing product, or present a product as an imitation or replica of a product with a protected trademark or trade name. Influencers have a unique relationship with their followers, which places them at an increased risk of exploitation by being misled. And in terms of online platforms and influencers, the Advertising Standards Agency has already undertaken a significant amount of proactive work on this topic and on the topic of paid for promotions when it comes to influencer marketing. And to combat this, the ASA requires influencers to identify posts that are advertisements, which is often done by including the hashtag ad. The ASA also operates a name and shame policy, whereby if it determines an ad is misleading, it will write to the influencer and the brand to notify them of non-compliance. It also publishes an online list of non-compliant social media influencers, detailing those influencers who have either failed to provide an assurance they would clearly identify ads, or having given that assurance, have reneged on it. This means effectively that the ASA will monitor them with a period of enhanced spot checks, and failure to comply can result in additional targeted sanctions, such as paid ad campaigns by the ASA highlighting the influencer's continued non-compliance and onwards referral to enforcement partners. The Advertising Standards Agency also has a dedicated quick reporting tool to report online scam ads in paid for space. And this includes ads on newspaper websites, paid for search engine ads, or ads appearing on social media. And examples will include false endorsements and clearly false or outlandish claims for products. For example, miracle cures, or that a device can save a large percentage of money on energy bills. And where it's important for those of you listening today in businesses is that influencers, as John discussed, have a relationship which is direct with the consumer and their followers. And so it's important to ensure that they don't go off-piste when promoting a product that they may have contracted with you to do. Finally, there are some other factors that businesses should take into account when deciding what action to take in response to an infringement of their intellectual property rights. As well as considering all legal and practical steps and remedies, we recommend you also consider PR considerations. while intellectual property rights protect your ideas and the hard work that you've undertaken in order to build a successful business, it's often the case that people can become incensed and concerned when they think their intellectual property rights have been infringed. And as John earlier discussed, it's not uncommon for an initial reaction to be to immediately raise court proceedings or send a strongly worded cease and desist letter. But one aspect of a response that's often overlooked is tone, and in particular in a cease and desist letter. Now, there will be occasions where a strongly worded letter is needed, but we suggest that in today's online world, any letter is likely to be widely shared online by the influencer or potentially followers. And in cases where there's a public perception of a David versus Goliath battle between an influencer, a micro-influencer, or an independent business and a larger company, public sympathy could lie with the smaller business or the influencer. And now examples in the real world of a heavy-handed approach that had negative PR implications for brands include BrewDog. In 2017, the company suffered an online backlash after the Guardian newspaper reported on its dispute with the owners of a family-run pub in Birmingham. The pub was called the Wolf Pub, and the owners had announced their intention to rename it as the Lone Wolf. While BrewDog eventually backed down and acceded to the name change, there was obviously negative PR implications for its brand, and the founder of BrewDog eventually tweeted, "Our lawyers got a bit trigger happy." Another example is Hugo Boss in 2020. The company had been sending cease and desist letters to small businesses and charities who were using the word boss in their names. And in support of these smaller businesses and charities, the comedian Joe Lycett, who has a large online social media following across a range of platforms, tweeted that Hugo Boss had cost small businesses thousands in legal fees and rebranding. And in support of these businesses, Lycett changed his name by deed poll to Hugo Boss. That obviously had negative PR consequences for Hugo Boss. And therefore, it can sometimes be beneficial to adopt a different tone. And where the infringer is a small company or it's a micro-influencer, and it seems as if they're not intentionally trying to profit by infringing your IP, a letter that is more educational than threatening may achieve the desired effect. A good example of this, which is easily accessible through search engines for you to read, is a letter that was sent by Netflix in relation to the Stranger Things franchise. And what was particularly effective about this letter was that, although written by Netflix's legal department, they were able to seize control of the narrative and garner public understanding and sympathy to their approach to protect their IP rights. The letter adopts a distinctly chatty tone and makes several references to the TV series, which is the intellectual property that the letter is seeking to protect. Now, in contrast to the heavy-handed examples discussed previously, the letter garnered appreciation online and actually resulted in many positive comments, retweets, and shares in Netflix's favour.
Okay, so bringing matters to a conclusion, the main takeaways from today's discussion is that there's a range of legal options to tackle problems that arise when you're dealing with business online and in particular with influencers. Which is most suitable will depend on your particular situation, but there are a range of both legal and non-legal options for you. Hopefully you're now aware there's some practical steps that can be taken, and the need is really said to be thoughtful about how you communicate with the person who may have been unwittingly using your brand or your content. So how you deal with the issue can be as important to the impact on your brand as the brand itself. So thanks for your attendance today. We haven't been able to cover everything. And in the series, what we've done is we've covered patent litigation, Scotland, across Scotland, England, and Wales, the protection of online images, protected by copyright and risk to reputation, and then finally in this session, how to deal with online content and advertising. I hope you found it useful. I've got a couple of questions that I'll just take just now, and if you've got any questions while I'm addressing them, just pop them in the Q&A. First is, when I don't have a registered trademark, can I use the takedown mechanisms that platforms have? I think the answer to that is, in our experience, it varies from platform to platform. Some platforms will only act on registered rights, taking the view that the certificate of registration is enough for them to act. Other platforms will look for evidence to support your reputation in the brand and essentially the passing off case. But because some jurisdictions don't recognise the UK concept of passing off, and instead it falls under a different test of unfair competition, it can be difficult to get them to act on that. So unfortunately, it's a rather on the fence answer of it depends. And the second question perhaps relates to that, and it's in relation to listings on retail sites. So platforms are saying that they're going to put a listing back up after I have submitted a takedown request. It's been taken down, and they've said that they will put it back up unless I produce a court order. And this is in the context of a copyright takedown. Again, I think that this is an example of the platforms looking for some sort of third-party verification of their rights, and they're broadly trying to stay away from resolving disputes between traders. You can see that if a trader has a competitor, one of the easiest ways to win in that competitive situation is to get the competitor's listings taken down by making false claims in relation to infringement. So the platforms are generally stepping away from that kind of issue and saying, go get a court order. Okay, I don't see any other questions. So what I'm going to do is thank you for attending. Thanks for your attention, and we'll close oh, something's just popped up. So one more second. Slightly related to the previous question, if we're finding that online marketplaces have hundreds of infringing material, is there something we can do that can help with takedowns? I think the short answer is yes. There are platforms, there are businesses who specialize in large-scale infringement, dealing with the large wholesale platforms like Alibaba and others. And I've just forgotten the name of the Edinburgh-based business, but it has Dragon in its name. But what they do is, instead of taking a legal approach, they're more relationship driven. So they work with rights holders. They will submit takedown requests on your behalf, but also seek to build relationships with the big platforms, so that the platforms know that you as a business have legitimate rights, and you essentially get priority from the random takedown requests that are submitted. Thank you. It's Snapdragon. So somebody else has submitted that it's Snapdragon. So that kind of provider is probably better than a pure legal solution, where the lawyers are only able to address the issue on a jurisdiction by jurisdiction basis. and instead you go to the heart of the issue and go to the platform. And that was our fire alarm test, if anybody was wondering. Okay, don't have any other questions. Feel like an auctioneer saying going, going, gone. But finally, I'll thank you for your time and I'll close the webinar. Thank you.